Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. In this episode, I want to discuss a question that is very important to both buyers and sellers. Is there an obligation on buyers to disclose buyers' marital status as part of the purchase and sale agreement? And simply put, the answer is yes. Here is the tension in that question. Some buyers don't want to disclose their marital status because they are concerned that upon learning their marital status, the seller will view their offer differently and even discriminate against the buyer because of the buyer's marital status. It might be that they are a same-sex marriage. It might be that it's two people who are not married. It might be any number of circumstances where in a buyer's perception, it is going to taint the seller's review of their offer. And so to avoid any opportunity for seller to discriminate against the buyer based on their marital status, they're just not going to disclose their marital status. And yes, it's important for escrow to know, so buyer broker will pick up the phone later and call escrow and tell the escrow company whether or not the buyer is married. Okay, it's not okay. Okay, I understand the buyer's mindset, but buyer brokers, that's not going to work for seller. And here's why. Let's start with an absolutely undeniable premise. No seller is ever allowed to discriminate against any buyer based on buyer's marital status. And so I understand the concern by buyers, and I hate to be Pollyanna-ish sounding in my dismissal of that, but the fact is sellers are prohibited from discriminating against buyers based on buyers' marital status. And so I can say all day long that shouldn't happen, that the answer is it can't happen. And if a seller is going to violate law, the seller is going to violate law, and I don't know how any of us are going to change that except listing brokers. You have to remove yourself from that transaction and make sure that that fact is communicated to the buyer and the buyer broker. I'm going to set that concern aside because there are certainly some sellers out there who will discriminate unlawfully against a buyer based on the buyer's marital status, but I don't believe most will. And it becomes an issue that is somewhat of a red herring in this conversation. So setting that concern aside, it's a legitimate concern, but setting it aside, here's why seller has to know buyer's marital status. Let's say buyer John Doe on a purchase and sale agreement. And that's all it says is John Doe. We don't know if John Doe's married or unmarried. We don't know anything about John Doe. But John Doe has a pre-approval letter from a lender that says John Doe is qualified to purchase this property. And so seller enters a purchase and sale agreement with John Doe. 5 days before closing, escrow title, they make a discovery, John Doe is married. John Doe is in the process of getting a divorce, but as of closing, John Doe is still married. And in this fact pattern, it's critical that John Doe is also getting financing. If John Doe is a cash buyer, then I care much, much less about this issue. But if John Doe, the buyer, is getting financing, then what do we know John Doe's lender is going to require from John Doe as part of the closing? We know that John Doe's lender is going to require that John Doe deliver to lender a title insurance policy ensuring the deed of trust. John Doe's signature on that deed of trust and the enforceability of that deed of trust as an instrument to foreclose title to that property. If John Doe is married, Washington State is a community property state. If John Doe is married, John Doe's spouse has an ownership interest in that property, a community property interest, even if John Doe and the spouse actually finalize their divorce 3 days later. At the time that title was conveyed, John Doe was married, which means John Doe's spouse has a community property interest in that property, meaning that John Doe's signature alone is not enough on that deed of trust. If the lender is going to come back and foreclose that deed of trust in the future, both John Doe and John Doe's spouse had to have signed that deed of trust. And failing that, the deed of trust will not suffice as an instrument for the lender to be able to foreclose title to the property. And what the lender is looking for from the title insurance company at closing is insurance, ensuring the company, the lending company, that John Doe does have adequate title in himself to this property. And the insurance company cannot give that insurance if, in fact, John Doe has a spouse at the time of closing. And so this transaction will be derailed. It will fall apart at the closing table because John Doe has a spouse who, in this late part of the transaction, is unwilling to sign a quitclaim deed. If the spouse would sign a quitclaim deed, then the title insurance company could insure title based on John Doe's signature on the deed of trust alone. But if there's a lot of friction in this divorce and the spouse isn't particularly gracious to John Doe at this late stage of the transaction and doesn't sign the quitclaim deed, then John Doe is unable to purchase this property and the seller loses the buyer at the closing table. And so listing brokers, you should be demanding to know the marital status of any buyer, particularly buyers who include a financing contingency in their transaction. It's just that simple. And when your seller learns the marital status of the buyer, they absolutely are forbidden from discriminating against that buyer based on their marital status. That goes without saying as it relates to this topic. That's both state and federal law otherwise. But as it relates to this topic, the seller who is asked to give a financing contingency to the buyer is entitled to know whether the buyer or buyers are married, and if so, to whom. It may be that we have two buyers on title and you say, give both of their names and say a married person. Could be that they're married to each other. It could be that they're both married to two other people. So it is very reasonable for seller and listing broker to inquire of buyer, is the buyer married or are the buyers married? And if so, to whom? If you have questions on this topic or any other, please visit warealtor.org and follow the links to the legal hotline. Thank you for being a Washington Realtors member.